He was already on probation. Then prosecutors revealed shocking new assault allegations involving the same victim. But when the defense asked for bond, the judge's response changed the entire courtroom. Watch what happens next.
2023 CR 10135 State versus Adam Gonzalez. Can I have parties announced?
ADA Jones for the state.
Orlando Castellano for defense.
And are you Mr. Gonzalez?
Yes, Your Honor.
All right. Defense, you filed a motion to set bond on the motion to revoke community supervision.
Yes, sir.
All right. You may proceed.
Judge, my client is asking that he be allowed to make a bond on the motion to revoke. He has some affairs that he needs to attend to, and we're just requesting that you set bond. The previous amount was $10,000.
State.
Yes, Your Honor. My understanding, and I am trying to pull it up, but Odyssey is being difficult. My understanding is that right now he is remanded without bond. He is not entitled to a bond, as this is not a deferred adjudication probation. Additionally, one of the allegations in the motion to revoke probation is not reporting, and I believe it was not reporting for over a year. So the state does believe that this defendant is a flight risk. Additionally, while on probation, the defendant picked up a new number 1 for assault against the same victim that is alleged in the case he's on probation for. Further, he does have another case out there for ag assault deadly weapon, although that case is being filed at large. That is also with the same victim. So not only is this defendant a flight risk, but he is a danger to this victim and potentially to the rest of the community, Your Honor. And so the state's asking that the court remand him without bond.
All right. So with regards to the new law, with regards to setting bonds, if the state is able to present to the court evidence of a prior assault and also or prior violence against the same alleged complainant, then he's denied bond.
Well, Judge, in regards to that, I believe that he's currently on motion to revoke. He's on probation for a nonviolent offense.
And just very brief response, Your Honor. That is correct. However, if it is for unlawful possession of a firearm by felon, however, if you look at the stipulations which the defendant stipulated to, there is family violence alleged in that with this victim, including with the weapon.
All right. Does anyone have the stipulations? I do see as a part of the court's orders, there was a no contact order against someone.
I believe that is in the clerk's notes.
Yes, Your Honor. I can print them if Your Honor will give me just a moment.
Your Honor, do I have permission to speak?
You may want to speak to your attorney before you speak. Counsel, if you want to have the court accept whatever evidence is presented and then recall this for next week for you to bring whatever evidence, if your client wants evidence brought in, I won't issue a ruling today.
Yes, Judge.
All right. So then what, and state at that time, if you'll have the stipulations.
Yes.
And then what we'll do, what I can tell parties though, since state you're asking that the court deny him a bond, everybody needs to have whatever witnesses they have, because the rules of, even though the law has changed, the rules of evidence and what the rules apply to has not changed. So denying a bond, increasing a bond, the rules of evidence still apply.
And Your Honor, just so I understand, my understanding is that he's currently remanded without bond. So the state's
Yes.
not asking to increase the bond or anything. It's defense's motion to reduce the bond or to set bond.
Well,
And so,
when they are remanded without bond,
Mhm.
that is only for a limited time. And the court does that for them to come back in court is entitled for a bond. Now, if you're saying, Judge, we're not going to ask that he be denied the right to have a bond, we're fine with the bond being set, that's something completely different. But if you as the state is going to say, I don't want him to have a bond,
sure,
then the rules of evidence apply.
that's fine.
Okay. All right.
Yes, Judge.
So when will people be able to have their witnesses? If you talk to Ms. Ferguson, and we'll bring everybody in.
Yes,
Now, mind you, if everybody's gonna proceed, and by everybody I mean state and defense, if y'all gonna proceed like the rules of evidence don't apply, then y'all won't need any witnesses.
It's Judge.
And I'm assuming people are gonna proceed as though the rules of evidence do apply.
Yes, Judge.
Yes,
Okay,
Judge.
so if y'all talk to Ms. Ferguson for when y'all need this set, but it'll have to be next week because if it's gonna be a contested hearing, I'll give y'all 20 days to prepare for a contested. So if y'all speak with Ms. Ferguson on the date to come back on a bond.
Thank you, Judge.
All right, thank you.
We can concur.
I'll see a while.
Odyssey always takes a while.
Mhm.
I think there's a movie coming out called The Odyssey. Around this
Okay.
3 hours, so even the movie's gonna take a while.
Well, hoping the Odyssey, the movie, is going to be good.
I'm joking, because our Odyssey is our system,
Yeah.
but it's horrible.
Yeah. Yeah,
But
Odyssey
if
is
you're
on
going
an
an
Odyssey.
Odyssey. It should take more than an hour. It needs to take hours because it's an Odyssey.
Right.
Otherwise, it's not an Odyssey.
Yeah.
What would we call it?
Otherwise, it's a trip, a sojourn.
No, I mean, it would be something less than a trip.
Yeah. Around the corner.
There we go. All right. So, Ms. Abrams, on this case, you said VTC did not accept him.
Correct. And felony drug court also did not.
All right. So, alternate amending. And again, what are we doing?
Adding moral record
MRT.
MRT. I don't remember what the R stands for.
Yes.
And
Or recognition.
thank
there.
you. Yes, Judge. And the a TAP evaluation and follow recommendation.
Probation. Anything else? So, when will the TAP be done?
We have to schedule.
How many weeks do you think it will be? Out of custody, you think? All right, Norma, can I have a 4-week reset for an update on his TAP eval? All
June
right.
8th. June 8th.
All right. So this is what I'm going to do. Ms. Abrams, I will go ahead and agree to sign the motion to withdraw. The only alternate amendment I'm going to do today is the alternate amend for TAP. Because I think once I see the TAP evaluation, it'll tell me if MRT and all of these other things are necessary. Are you okay with that, Ms. Abrams? All right, that's what we'll do. And counsel, if you'll stay on the case and be back on June 8th so we can see what's happening with the TAP evaluation.
Yes, Judge. And just to be fully transparent, I am here filling in for Kyle Simpson. This is his client. So it may be him, but
Okay.
if that's okay with you,
Yes.
otherwise I'll be here.
All right, thank you.
Thank you.
This case took an unexpected turn, and the next hearing could decide everything. If you enjoy real courtroom drama, intense judge moments, and shocking legal twists, hit subscribe now so you never miss the next case.